Stay tuned for the next edition of Zoom Landlord Tenant Talk Radio. The opening topic will be Los Angeles County Raging War on Landlords. Hello. Yes, another edition of Zoom Landlord Tenant Talk Radio coming at you every Saturday at 3 p.m. You know, I took a phone call today at the office, and a landlord called me up and he asked whether he could reject an applicant because they had too many tattoos. So I tweeted about this and I was asking everybody's opinion on this. But of course, the answer is that you are allowed to discriminate unless it's a protected class. The protected class, for example, would be race, religion, sex, marital status, national origin, age, disability, etc. So since tattoos are not part of that class, is it permissible to reject an applicant based on the fact that he has too many tattoos? Well, there's one more category that I didn't talk about, and that was under the old Unruh Act, which says that you cannot arbitrarily discriminate. And what that law meant was that, for example, if you didn't want to rent to people with red hair, that would be considered arbitrary discrimination, and of course is outlawed in the state of California. Well, having too many tattoos and rejecting an applicant on that basis is also considered arbitrary. So the answer to the question is, and what I told my client, no, you cannot reject an applicant because they have tattoos. Now, if you were listening live, the name of the song was Mellow Yellow by Donovan. It was released in October of 1966. In the 60s, there was a widespread rumor that you could get high by smoking dried banana peels. People connected to this song and decided that it must be about that. Well, Donovan later clarified that the banana peel drug story was actually started by Country Joe McDonald, and Donovan only heard about this rumor 3 weeks before the song was released. So the myth actually attached to the song as it didn't inspire it. And the reason why I picked that song was because I would love to know what the Los Angeles County Board of Supervisors are smoking, which brings us to our opening topic. And our opening topic is LA County's war on landlords. LA County's war on landlords. There is a new reality for Los Angeles landlords. As of February 3rd, 2026, the Los Angeles County Board of Supervisors voted 4-1 to double the eviction threshold. Now, the core rule about this new law is that landlords cannot file for non-payment of rent until the tenant owes more than twice the fair market value as published by HUD, the Housing and Urban Development. Now, I want to caution you that this only applies to unincorporated areas in the county of Los Angeles. Now, most people really just don't know what that means. If you're in a particular incorporated city like Santa Monica, West Hollywood, Los Angeles, these are incorporated cities. Beverly Hills, Burbank, Glendale. These are incorporated cities, so they don't qualify. But there's many areas of LA County that do not have an incorporated city. I'm going to show you a chart right now. And this is the county of Los Angeles. You can see that it's mostly yellow, but wherever there is a white space, for example, this big area here, which is called Topanga, not too far where I am, that's an unincorporated area of LA County. People think Altadena up here is a city. It's not. It's an unincorporated area of LA County. You have right here in the smack dab in the middle, you've got East LA. That, again, is unincorporated. So all the places that are white on this map is where you have a county is involved and they control. And now we have to deal with this, quote, fair market Rule. So what is the fair market? And that is where it's a governmental benchmark based on bedrooms, not on the actual rent you're charging. So let's take a look at the fair market value chart, which I have here. And as you can see, this is based on the Housing and Urban Development fair market value based on whether it's an efficiency apartment or a one-bedroom or a two-bedroom. So let's take, for example, the way this law is working. If it's a one-bedroom apartment, it is determined that at this moment in time that the fair market value is $2,085. Well, based on this new law, you can't serve a 3-day notice unless the amount that the tenant owes you exceeds 2 times the fair market value. This is insane. So, for example, you would have to wait for a one-bedroom for the tenant to owe more than $4,170. And if it's a two-bedroom apartment where the fair market value is $2,601, you can't bring forth an eviction unless the tenant owes more than twice. This is this new rule. That would be 5202. Now, in the city of Los Angeles, and it used to be the unincorporated areas of LA County, it was only 1 month's rent. Well, now the county, in their ultimate wisdom, have now beefed it up, and now you have to have 2 times the fair market value. So let's take, for example, where you're renting a unit and you don't really get much for it. So you're not a quota gouger, as the media would love to call you. And you're charging $1,800 for a 2-bedroom apartment. So now you're forced to wait 3 months, my friends, before you can bring forth an unlawful attainder. You can't even serve a 3-day notice to pay the rent. So you're looking at a mandatory period of about 90 days, 3 months before you can first bring forth an eviction. Now, what does this do? This creates an incentive for tenants to stall. Why tenants stall? Very simple. The high threshold acts as an invitation for tenants to stop paying rent because they know it's going to be at least 2 to 3 months buffer before you can actually even serve a 3-day notice. And of course, we know, because I've talked about this in a previous show, that once you file an unlawful detainer, if you do not get a judgment within the first 60 days, the record is permanently sealed, which means that the tenants can drag out their cases, which is what they do, to ensure that their record is hidden, and then they move to another location and they prey upon the next unsuspecting landlord. Now, let's talk about how this is going to allow tenants to basically live 1 year free rent. Again, I'm going to share my screen. I have another chart here. And there's my chart, the 1 year rent-free timeline, the 1 year rent-free timeline. We'll start with phase 1, which is in blue here. And that is that you're going to have to wait about 3 months, at least 2 months, before you can bring forth an unlawful detainer action. This is insane. So now you're 3 months in the hole. The tenant has chosen not to pay you for no particular reason other than he doesn't have the rent or just doesn't want to pay you. Then what happens? We move into phase 2. Once you finally have the right to serve the 3-day notice, then you have to wait for that to expire. And of course, it's 3 business days. You have to exclude Saturdays, Sundays, and judicial holidays. Once you get to the expiration, then you have to file a lawsuit. Well, then you're going to have to contact an attorney who's going to have to assist you. We have to prepare the paper, and we file that with the court. We do have to wait about 3, maybe 4 days for the court to issue a case number. And then it's going to go back to the law firm, who then gives it to a process server for serving. But you see, tenants are pretty smart. Unlike a notice to pay rent or quit, which all you have to do is post it on the door and mail it if you can't get the tenant to come to the door, that's not the same for a service of a lawsuit. The service of a lawsuit has to be put into the tenant's hand. Well, if the tenant's home and he doesn't open up the door, you can't serve your tenants. So many tenants, more than I would like to admit to, do dodge service, never answer the door. And by never answering the door, you can't get them served. So what we need to do in that situation is we file, after a week of trying, we then file something called an order to post that allows us to serve the tenant by just posting it on the door. But that requires a court order. So usually it's going to take the court about a week to do so. Some courts take even longer, but let's pretend about a week. Once the court signs this order, I can then immediately serve the tenant by posting it on his door. But now I have to wait 15 business days before I can take the next step, which is to file a default on this case. 15 business days. You're talking about 25 days. You can see the time running with regard to, number one, that I had to wait so long to serve a 3-day notice. Then I've got to wait for the length of the notice. Then I've got to file the lawsuit. I've got to try to serve the tenant for 1 week who's evading service. I've got to wait another week for the judge to sign the order to post. And then I've got to wait 15 days thereafter. But then what happens? Well, the tenant's going to file an answer. Well, if you file an answer to the lawsuit, I've now got to go to trial. And if the tenant asks for a jury trial, you're going to get a trial date within the first 30 days or less. But the problem is there's going to be no courtrooms available, and therefore the case is going to get continued. So you're looking at another 2 to 3 months before the matter actually goes to trial. And finally, you can win your case after this period of time. Now, once you win the case and you have a judgment, well, we got to do one more thing. Well, what's that? Well, I've got to get a writ of possession. That's a court order, which I have to deliver to the sheriffs. But those pesky County Board of Supervisors, they've done something else. They've intentionally told the sheriff's office to slow walk evictions. Right now, it takes, when you deliver the paperwork to the sheriff, it takes at least 2 months for the sheriff to do a lockout. 2 months for the sheriff to do a lockout. Literally, you can sit there 1 year without getting your rent. 1 year without getting your rent. And this is an undue hardship, of course, on landlords. Small mom and pop landlords cannot absorb a year's worth of lost rent while they're still paying their property taxes, their mortgage, their insurance, their other upkeep. And in fact, what the county has done is that they've made a charitable burden on landlords, effectively forcing them to provide free social housing without compensation. And one more thing, if you have the unfortunate situation of having a Section 8 tenant and you're in this unincorporated area of LA County, think about it. When you have a Section 8 tenant, the tenant pays only a small percentage of the rent. And let's pretend the tenant's only paying $200 a month. Well, you're never going to get above the threshold. Never, because you can only ask for rent more that's less than 1 year old in a 3-day notice, which means the County of Los Angeles has effectively stated to any Section 8 tenant who's in their jurisdiction, you cannot be evicted for failing to pay your share of the rent. You're never going to be above the threshold. And that's because you have to only ask for rent that's less than 1 year old. So you're never going to get to the threshold. So the county has now made it impossible to evict a Section 8 tenant for those areas that are in an unincorporated area of the county, because based on this 2 times the fair market value, you're never going to be able to get there. So what's the conclusions to all of this? Well, number one, check out your map to see if, in fact, your property is located in unincorporated areas of LA County. Remember, in the city of Los Angeles, and it only applies to the city of Los Angeles, it's only 1 month's rent. All other cities in LA County do not have this fair market value rule. But if it's the city of Los Angeles, it's 1. So make sure you know that you're in a jurisdiction, and hopefully you're not in an unincorporated area of LA County. The next thing is, for these areas that require, the fair market value, never never take a partial payment of rent because you'll never get above the threshold. So if the tenant is offering you half a month's rent, you do not have to accept it. You can return it even if he sells it to your account because you have the right to accept the full amount of rent of what's owed at that moment in time. Also, if you are renting out a unit to someone, let's think this out. If you get yourself a bad tenant based on what the county is doing, you could be without rent for a year. So what does that mean? You've got to raise your credit standards. You have to have at least a 700 credit rating. You have to make sure that that applicant can show you proof that he paid at least 6 months, the last 6 months rent to his current landlord, and there's nothing bad in his credit history. Because if you get yourself a bad tenant, it's really simple that you'll be without rent for an entire year. Also, when you're setting the rent for any tenancy that you're going to create, so you have a vacant unit, you want to make that rent way above the fair market value because you don't want to have to wait 3 months. So make sure that you're charging way above the fair market value for a 1, 2, or 3 bedroom. Also, don't be fooled that this only is regarding unincorporated areas of LA County. I can easily see the city of Los Angeles following suit, and it's going to follow suit with other municipalities in LA County as well. So make sure that you screen your tenants well. Make sure that you have charged the maximum that you can possibly charge, and make sure that it's well above the fair market value. And that, my friends, concludes the topic of Los Angeles County's war against landlords. What we're going to do now is we're going to open it up to questions and answers for those people that are in the Zoom meeting room. And you know the rules. This is only for informational purposes only and does not qualify for legal advice. If you do want to talk to me and you're in the Zoom meeting room, please electronically raise your hand and I will get to you. This program is only for general questions only. If you do have a case with my law firm, please save it by calling me on Monday because God knows I'll be in the office on Monday. And if you are talking to me, please leave your camera on because it does make it much more enjoyable for the audience and myself. And you guys watching on YouTube, if you could do me a favor, if you like what you're hearing about landlord tenant law and property management, if you could hit that like button and subscribe to the channel, I'll be happy to call on you if you ever do get into the Zoom meeting room. And by the way, if you want to get to the Zoom meeting room every Saturday at 3 p.m., just go to my website, evict123.com, and we're happy to give you the credentials to get into the Zoom meeting room immediately. If you don't get to ask a question, you guys know that my office at no charge, whether you're a client or not, you can just call our office 1-800-77-EVICT, and we're happy to answer any questions dealing with landlord tenant law. And we do have a new phone system now, so the phones are getting answered immediately, so there's not much of a wait time anymore. And with that, we're going to open it up to our first caller of the day, and that is Suzette. I'm going to ask you to unmute yourself.
Hello, Dennis. How are you?
Hello, Suzette.
That was quite disturbing because I do have the duplex that I rent and I live in is in the unincorporated area.
Sorry that they did that to you.
Yeah, but this question is regarding, I have 2 questions. This question is regarding a property, a condominium located in the city of LA. So, when I serve a 3-day notice on the tenant, do I have to give them the proof of service?
No, you don't have to give them proof of service. You do have to give them a form called Right to Counsel. That form is on my website at evict123.com. You do have to make sure that when you serve that notice that you're above the fair market value for 1 month's rent since you're in the city of Los Angeles.
Yeah, they're 3 months behind. And
Oh,
then
yeah, you need to start that case immediately. And you do know in the city of Los Angeles, you do have to upload that notice to the city's website at the Los Angeles Housing Department.
I do. I wanted to serve the 3-day just in case they pay. within the 3 days? Because if they don't, then I'll call you to do the eviction.
And I appreciate that. And thank you very much for your questions. We're moving on to JTK. I'm going to ask you to unmute yourself.
Oh, hi, Dennis. I had like a what if I had a duplex with a garage in the back and it's RSO and they wanted to do a ADU and the tenants use half the garage each side. How would a guy attack that?
Very simple. If you want to convert that garage into an ADU, you have the right to do so. Since the tenants, as part of their tenancy, were using that garage, you have to serve them with a 30-day notice that they will no longer be able to use that garage, but you also have to offer them a decrease in rent. There's a chart, and I believe I have that chart on my website in the legal issues section,
I see.
and it tells you what the amounts that you should have to offer them depending on how much street parking there is. If there's a lot of street parking, then the parking garage is not worth as much as if it's very tight street parking. So there's a chart on my website in the legal issues section.
I see. Yeah. They used it for storage, basically. Yeah. All right. Thank you.
Thank you. Moving on to Rosanna, I'm going to ask you to unmute yourself.
There we go. Can you hear me now?
Perfectly.
Okay. Anyway, as you may know, I'm one of your biggest fans. I'm an attorney from the Riverside and San Diego area, so I don't deal with a lot of these cases, but had a situation come up, and it's with insurance. It seems like the insurance companies now are refusing to write or renew policies on rental condos. You can get insurance on your own condo or your own home or your own freestanding property, but State Farm, Farmers, and Liberty Mutual are out of the market as far as writing policies on rental condos. Well, this threw me for a loop for about a week, and I did some serious research. Of course, you were out of town last week, so I couldn't call you and ask, but I had a few people that I could call. And I did locate someone who was able to write a policy. They, I think their underwriting or something is outside of California, and they were able to, and they actually did better prices than Liberty Mutual or Farmers. And I thought I'd like to give a shout out if you'd be interested.
Sure.
Give you
I
the name
think
and number.
this is a forum that everybody helps each other. Just out of curiosity,
Yes.
the California Fair Plan wouldn't insure a condo?
You know, I didn't get that far.
Okay.
I didn't
So
even know
what's the
about
name of the
California Fair
company that
Plan.
you went with?
I went with a Cord Insurance or Cord Williams, who's the name of the broker, and it was OBIE Insurance,
Opie? How would you spell that?
OBIE.
OBIE Insurance. Well, everybody, if you're having a problem getting insurance for your property, you might want to check that out. Anyway, thank you very much, Rosanna. Good information. We're moving on to Jeff Wolpen. How are you?
Yes, hello, Dennis. My question is regarding when I can increase the security deposit on my Van Nuys non-RSO single-family residence after the fixed term becomes month to month.
I don't think you can. I think the laws dealing with security deposits state that once you set that you can't increase it. I know the city of Los Angeles says that you can increase it just the same percentage, but if you're not under RSO, I don't think you really have the ability to check that based on 1950.5 of the Civil Code.
I'm only increasing it to the same 1 month, equal to 1 month.
I know. I think if you read the code section, the way they've amended it, that you're only allowed to, whatever they move in on is what you're stuck with.
Hmm, Okay.
And by the way, you don't have a relative by the name of Mark, do you?
No, it's my last name is a little unusual. So yeah.
Okay. I knew a guy growing up. Anyway, thank you very much. Moving on to Talon.
Hi, Dennis. Can you hear me?
I can.
Thank you so much for taking my call. I have some notes so that I don't take up too much of your time. I have a single family home in the city of Palmdale. There's no rent control, and it is not unincorporated as far as I know, what I've been told. I served a 60-day notice to vacate in 2021, but I didn't follow through with it because they went into panic mode. And anyway, and I wasn't desperate back then to sell it. And so anyway, I'm going to make a long story short. Since then, I've notified them multiple times in writing to look for other options to move out. And now I'm stuck with a situation where she's claiming an alleged slip 24 and
You're breaking up a little bit,
I
Talon,
understand
just to
there's
let you
now
know,
a
but go ahead.
Oh, sorry. I understand. Oh, did you hear about the alleged slip and fall that they're
Yeah,
claiming now?
I
Anyway,
heard that part.
there's,
Correct.
I understand there's a waiting. Oh yeah, I understand now there's like a 6-month waiting period so that I'm not considered retaliatory if I do anything.
Well,
My
if you're
questions
planning
are,
on,
well,
if you're
anyway,
planning on,
also,
let me interject. If you're planning on selling the property and you have a broker lined up, then it wouldn't be considered retaliatory because your dominant intent is to sell the property. It has nothing to do with the slip and fall. However, I'm going to hope that the tenants moved in prior to July of 2020, correct?
oh, they've been there almost 15 years. Rent is
Okay,
way
so
below market.
all right, so then
Um,
that's good. So on that basis, you can serve a 60-day notice. You need to also serve them a notice that their property, that your property is exempt from statewide rent control.
mhm,
And those forms are on my website. But yes, you can issue
mhm.
that notice, and I would just have a broker lined up that so that if anybody claims that it's retaliatory, it isn't because I'm selling the property and here's my broker. Anyway, thank you very much. Moving on to Kevin P. I'm going to ask you to unmute yourself. Kevin P. Okay, Kevin, we are going to move on to Harold Rhodes, sir.
All right, Dennis. What would life be like without you?
Well,
God, man.
you found out last week, and I can tell you, and I can tell
I didn't
you,
even know you were gone until then I did find out.
yeah, no, it was, I went to New York for the Laker game. We
Oh,
lost,
that's right.
right?
Did we
And then,
win, by the way?
no, we lost,
Yeah.
and it was like 19 degrees. And from a guy who grew up in Southern California, it was pretty damn cold there.
Rugged. Anyways, okay, so this question regards actually a friend of mine who's a tenant, and she was asked to leave because this family has to move back in. They have 3 houses on a lot. What I'm wondering is, I'm thinking they're under RSO, but I'm wondering, they have the ADU, the extra house that she's living in, that they built like, I think like 4 years ago. But the main property is before 1978 on the lot. So would that property be under RSO, or is it just the property that she's living in determines?
Well, first of all, she's there's a few houses on the lot. Is that what I'm understanding?
Yeah, this is like Woodland Hills area where yeah.
Okay, but there's more than one house on the lot and they're all separated. Is that what you're saying?
Yeah, one of the houses that they use as an office, the other, somebody's been living there. And then this new one
Is
Good.
she in the newer house, the ADU?
Yes, she's in the newer one.
Okay, so I would need to know the bedroom count, but generally they can ask her to move on the basis that they want to put in a family member. They do have to pay relocation on that. It's anywhere from, I don't know, $10,000 to $26,000, depending on whether she has children or not, or if she's over 62.
Last
But they
question.
can ask her.
Can you refer somebody on the tenant side?
She could just call the office and we'll look it up for her. It's
Okay,
no
cool,
problem.
cool. Sounds good, man. Thanks, bro.
All right. Thank you. Moving on to George Kasabian. Going to ask you to unmute yourself.
Hi, Dennis. Can you hear me?
Perfectly.
A long-time listener. Thank you for taking my call. I got a question. One of my tenants, I had a new tenant that moved in January 1st, and she calls me today. She says she wants me to evict her daughter because her daughter moved in with her, and she had some conflict with the police and getting involved in San Bernardino. She's asking me, can you evict my tenant, my daughter? And she can't get the daughter out.
Right. And your position should be This has nothing to do with me. Take care of your
All
own
right.
family.
Yeah, she says she called the police and the police told her you have to evict. I can't, that's not part of my business, right? She's currently, there's
Has
nothing.
nothing to do with you. However, she could bring forth an eviction. She doesn't have to be the owner of a property to bring forth an eviction.
Okay, sounds good. And then can I ask you one more question, Dennis?
Yes, sir.
I have a property in Altadena that we have one of our bedrooms we're renting out to a family member. And I'm getting LA County is asking me to register for rental registry. Do I need to register it if it's a one bedroom rental? I mean, one of the bedrooms they're renting out?
Are you renting out more than one bedroom?
Just one bedroom.
And who do you own the house?
Correct. I live
You
part of the house. Yes.
you live in the house.
Yes.
And does the person in that bedroom, does he have free reign of the house? He can walk into the kitchen or the living room?
Correct. Yeah. She's basically a roommate.
Yeah, I think it's a larger situation. I don't think you need to register that, but I would check with the city. I don't think they analyzed it from the fact that they're not really a tenant. They're a lodger under Civil Code Section 1950.5. So I might try to go back and ask for their legal counsel on that one, but I don't think you do.
Okay. Thank you.
Moving on to Sonia. How are you?
Yes, Dennis.
Hello.
Hi, thank you. Quick question. I'm also asking for a friend of mine who four units in the city of Glendale. She's telling me had put in the contract that she as a landlord pays for water and trash. One of her tenants just recently was asking because apparently through the city of Glendale, everybody 5 units and below, they are charged a rubbish charge. That fee increased. So he's asked, they just realized the discrepancy. So she is wondering, can she do a 30-day change of, what is it?
30-day change of tenancy?
Yeah, to clarify that the tenant has to pay for the rubbish and she's paying for the bins to be supplied, something like that. But can that be done?
I'd really have to analyze the contract before I could answer that question. I have to see the exact language in the contract, whether the tenant is responsible for these charges or not. So you might have her give us a call.
Okay, well, I'll do that. Thank you so much.
Yeah, some questions you just can't answer outright because if you're dealing with contracts and other documents, they really have to be reviewed before you give an opinion on these. Moving on to Jim Polina. How are you, sir?
Hi, Dennis. I tell you, those Lakers are nail biters. They pull out victory in the last fourth quarter of almost every game.
Well, you know something, it was funny. We went to the game on Thursday. We were playing the 76ers, and I'm sitting in my seats, and I have pretty nice seats, but I got a phone call from my season ticket rep, and she said, follow us, and we got floor seats. So I was sitting next to Denzel Washington. I was having just a great time, and the Lakers did win in the fourth quarter. So I was pretty stoked that day.
Nice. Good for you. Sounds fun. All right, couple questions. In my lease, I stipulate that I will not turn over the keys, even though they've paid the first month's rent and security deposit in full, unless they have all utilities transferred into their name. Is that enforceable or legal?
Absolutely. I don't see anything wrong with that. You don't want to have the utilities in your name so that you're still on the hook. So I think that's a very a good basis of doing it. However, the other way of doing it is just informing the tenant that, as of March 1st, the utilities are turned off, so you better get them on in your name because there will be no utilities as of March 1st.
Good idea. Okay. Second question is, you have repeatedly said there's no such thing as pet rent or pet fees, but yet I keep hearing other attorneys saying there is. So
yeah, I don't think there is. It's It's a security deposit is defined under the law, and it's exactly what you can get for a security deposit. Generally, it's 1 month's rent, unless you're one of the exceptions. So when they say pet deposits, they really doesn't exist. But I do see
not
most
saying-
landlords are charging it.
No, I'm not, Dennis, I'm not talking about deposit. I'm talking about pet rent and pet fees.
Well, what's a pet fee, my friend?
Just for the added cleaning for like hair.
Well,
and
listen,
fur,
if you wanna rent a unit for $2,000, for example, but if you have a pet, then the rent for the unit is $2,100 per month. I don't have a problem with that. Just like if 4 people, I'm gonna charge $2,000. If it's an additional person, then I'm gonna charge an extra $100. I don't have a problem with that. But when they talk about pet deposits, that's not in accordance with the law.
Right. Right. Okay, thank you.
And thank you. Moving on to a number, 643-021. I'll ask you to unmute yourself.
Hi, Dennis.
Hello.
I've been trying to get the video, but I just can't do it.
It's okay.
Anyway, is there a site I can go to see if a rental applicant is a repeat or a serial suer or a suit filer?
The problem with that is you want to obviously go to one of the associations, the Apartment Owners Association, and there are many of them. You want to run a credit check, and you also want to run an eviction check. But the problem is, and we had a show on this, is that if a tenant has been evicted, but it took longer than 60 days to obtain a judgment, then that record is sealed. So you really have no way of knowing whether this guy is a tenant or not, being evicted over and over again. Of course, you do want to run that eviction check to see if there's any evictions in his history. However, again, what you need to do is say, I need proof that for the last 6 months that you paid your current landlord. That will weed out somebody who just got evicted.
No, I was talking about somebody who does a lot of trip and falls, or, you know.
Oh, that's easy. You can just go to for example, the Los Angeles County Court website, the Superior Court website. You can run what they call plaintiff defendant index check. You can put in that person's name and see how many times he's either been involved in a lawsuit, not an eviction, but another lawsuit, either as a plaintiff and a defendant. And if you see he's done a lot of slip and falls, that would be perfect grounds not to rent to him.
Right. Thank you so much.
Okay. And we're going to move on to a phone number. I'm just going to give the last 4 digits, which is 4379. I'm going to ask you to unmute yourself. 4379.
Hi, Dennis. How are you?
I am fine, thank you.
Yes, Dennis. I know you spoke a couple of weeks ago about the 30-day notice to pay and 30-day notice to quit for Section 8 tenants.
Yes.
Does that apply in only unincorporated, or just the entire state of California, like all areas?
Unfortunately, it's the
As far as
entire
the-
state of California, not just unincorporated.
Okay, that's all I needed to know. Thank you so much.
Good question. Moving on to the letter D. I'm going to ask you to unmute yourself.
Hello, Dennis. Thank you.
Hello. Oh, you got to talk, my friend, unless you're having a problem with your mic. Okay, we're going to move on to, let's move on to Mohammed. I'm going to ask you to unmute yourself.
Good afternoon, Dennis, and thank you for your time. I'm acquiring a building, and some of them just got rent increase starting March. And I'm planning to put sub-meters for their water usage, so they are responsible for their water use. Can I give them that a 30 days change in tenancies, or is it going to be considered part of the rent increase?
First of all, what city?
It's in Apple Valley.
Okay, and this is an apartment house that was built more than 15 years ago?
9, yes.
Okay, so all you can do currently, actually, I'm not exactly sure what Apple Valley is. It's about 8%. You can't charge existing tenants, put in sub-meters and then make them pay for those utilities. That would be forbidden. You can do that for new tenants coming in, say you're responsible for the water and electricity, et cetera, but you can't do that to existing tenants. You're stuck with whatever the rent increase is for San Bernardino, which is approximately 8.5%.
So the water, the utilities payment is going to be part of the rent increase?
It has nothing to do with the rent increase. If you can't ask the tenants to pay for the water, certainly as to existing tenants. New tenants coming in, yes. If you sub-meter the building, new tenants coming in, you could put that they have to pay for the water, but not as to existing. You can just get whatever the rental raise rate is for San Bernardino under the Tenant Protection Act.
Wouldn't be considered as like 30 days or 60 days change in tenancy term?
You could change the terms of the tenancy, but it's just not going to be legal. You're not allowed to do that.
I see. All right. Thank you so much.
Thank you. Moving on to Salvador. How are you, sir?
Good, Dennis. I had a question. I live in the city of Whittier. We've talked before, and I want to be able to rent out the rooms. I have it's a 4-bedroom, probably have 2 or 3 people. Now, I want to use your contract on each person. Now, is there a rule on an eviction if I get a senior citizen 60 plus? That if they don't pay the rent, is it hard for me to evict them or what? Because now I'm dealing more than one person.
Okay.
I'm going to be living.
The age of your tenant has nothing to do with being able to evict them or not. Okay. That has no play in it whatsoever.
Okay.
But
so
you might want to check with your municipality to see if they allow you to rent rooms. Some of them don't.
Okay. Thank you.
Thank you. We got a lot of callers today here. I'm going to pick on new people. Andy, I'm going to ask you to unmute yourself.
Hi, Dennis. I'm sorry about the camera. I still can't get it to work.
It's okay.
So my question has to do with a condo in the city of Los Angeles. My tenant is leaving, and I've checked with your website, and I spoke to Jeff at the AOA, and I'm unable to find a standalone form that allows the tenant and I to agree to deliver his security deposit reconciliation and all the pictures electronically by email as opposed to physically.
I don't think you need a form. Just write something and have them sign it saying it's okay if I deliver this to you electronically. That's all.
Simple as that. I was hoping that somebody who bothered to go to law school might want to write that.
It's just a simple one sentence. That's all. I don't think it requires the services of an attorney. Anyway, thank you very much. Moving on to Siomas Flores. Ask you to unmute yourself.
Yes, thank you, Dennis. I have a question regarding an apartment building that I own in Inglewood. If I'm serving a 3-day notice to pay rent or quit, do I also need to attach the notice of right to cancel, or is that just in Los Angeles?
That is not part of the city of Inglewood, so no, you do not have to attach that.
Okay, and once I do within the 3-day notice, which I did serve, my son happened to go and try to put in, he was working on the building, and the tenant attempted to pay him in cash. Is he obligated to accept the money?
If he's not authorized to accept the money, then the answer is he doesn't have to accept it. He's just a worker on the property, even though he's related to you. I'm sure in the 3-day notice, you said specifically how rent is to be paid.
Yes, he does accept rents, but at that moment, he did not have his receipt book with him. He was just there running an errand, but we did put the office address there. So I'm wondering.
Yeah, I think you could have a problem with that. If he was authorized to accept it, he should have accepted it. Was he paying just cash?
Yes, he was.
Okay, well, then I would have said, well, let's go get a piece of paper someplace and I'll just write a quick receipt. That's all.
Okay, correct. Thank you so much.
All right, bye-bye. Alan Zaman, I'm going to ask you to unmute yourself.
Hi, Dennis. I hope you're doing well. I just had a question to ask you regarding the AB 1157. Do you have any recent updates regarding that? I believe recently it had passed, and just wanted to see if you have any recent information with that.
I'm not familiar with the number. What is it in reference to?
Assembly Bill 1157. I think it was regarding the rent cap limits for landlords who own single family and how much of an increase they can do on those properties.
I'm looking it up now. First of all, was an electrical and gas corporation hand? No, I don't know. I haven't heard that. And this is talking 1167, AB 1167 talks about electrical corporations and gas. So I'm not familiar with that one. And there is no limitations currently on single family homes. You can raise the rent to whatever you like. And I doubt they
Got it.
did try to knock that off in the last election, but it didn't pass. So I think we're fine on that.
Great. Thank you so much.
All right, moving on to MK Dell. I'm going to ask you to unmute yourself.
Hi, Dennis. I'm a little bit nervous. I have a general question about the Tenant Protection Act. If the master lives inside of a unit apartment and leases 2 rooms to 2 roommates, does this situation qualify as an exemption of the Tenant Protection Act? Meaning,
No, I think they're all under the Tenant Protection Act.
so there's no exemption?
Not that I'm aware of. You're the tenant, but you have subtenants that you're renting to. And so it's a tenancy, and whatever the Tenant Protection Act, there's no exemption on that.
So, I'm not the owner. I'm renting.
No, well, I understand you're the tenant, but you have subtenants. I
So-
understand you're not the owner, but you're still a landlord, and landlords are subject to the Tenant Protection Act.
Okay, so I guess I'm trying to find out about the just cause, if I have to have just cause rules.
Yes, you're going to need just cause to evict these tenants. Absolutely.
So, okay, well, obviously I need your help, so I'm going to be calling you very soon, and I appreciate your time, and everyone is very knowledgeable, so, I appreciate it.
Thank you very much.
Well, thank you.
Okay, we're moving on to, let's try Kevin P again. Did you figure out your mic problem? I guess not. Okay,
Yes, I'm here. I'm here.
You're there. My
Dennis, how
God.
are you? Happy Saturday.
Happy Saturday.
Thank you. Question, RSO LA City. We want to do cash for keys. The issue we have with the tenant is that they've agreed to the amount. The issue is that the lease is in the mother's name. The mom is 70. The lease is 24 years old. And the 2 adult kids that live there, they're not on the lease. So we want to write the cash for keys contract in the names of all 3. The daughter is telling me just write it into my name and my mom's name. What should we do?
Well, I would write it to all 3 adults because you don't want someone not to have to move. Okay, so maybe the 2 people who sign it, they grab the money and move, and then you're left with a unit that's occupied. So it makes absolutely no sense. Everybody's got to get out. All right, anyway, thank you very much. Let's move on to, let's see here, somebody new here. Okay, I'm going to take a couple more. Let's go back to Jeff Wolpen. Did you have another question?
Yes, sir. You just mentioned it earlier to another person on the webcast that single-family homes are not subject to not to limitations on rent increases. You can raise it to the market. But what about this anti-price gouging law, which limits increases to only 10%?
Okay, so I don't believe that law is applicable. If you have a vacant unit, you can certainly raise the rent to whatever you like. It's under the Costa-Hawkins Rental Housing Act. that states specifically for a townhouse condominium or a single-family residence that there are no rent limitations. That law starts with the phrase, notwithstanding any other law, you can. I don't think that quote state of emergency, again, it only applies to tenants who were impacted by the fire to begin with. And I don't know who that is, but at this point in time, more than a year out from that fire. And again, there was only 16,000 homes and businesses that were impacted, with like 3.5 million homes and businesses in Southern California. So again, you can raise it to whatever you like. And we're going to take one more. Let's go on. Well, we'll start with what we did, was back to Suzette. Did you have another question?
I do, Dennis. So the LA City, the condominium, they charge for parking. So I charge the tenant for the parking. So since the tenant hasn't paid me any rent, would it be legal for me to tell the HOA that I no longer need parking?
No, you can't remove an amenity that the tenant has. You have to go through the eviction process.
Okay, all right, that's it.
All right, thank you, everybody. I'm going to call it a day here. I appreciate everybody coming out. You know we're going to do this next week on Saturday at 3 p.m. You guys who are watching on YouTube, if you could please subscribe to the channel and hit the like button, because you will get a lot of information dealing with landlord tenant law. If you do want to leave comments in the section there, I do get to those comments and I will answer your questions. Once again, our office number is 1-800-77-EVICT. And if you got a landlord tenant question, I don't care who you are, we're going to answer your questions for you. And with that, you guys have a great weekend.